Well,
you guys insist that you are still in the majority because the 4 members who were kicked out still are still kicked out.
Well, Samson, thank you so much for the opportunity, and I know I would equally get the time to navigate.
Not necessarily. Not
all
necessarily.
the areas.
I had a number of questions for him. I may not have the same number of questions for you.
All the areas. Well, I want you to ask the same number of questions because they are all areas that I equally also have a position on.
Let's start.
So, first and foremost, the 1992 Constitution is very clear. And if I take you to Chapter 1, Article 3, it says Parliament shall have no power to enact a law establishing a one-party state.
That's correct.
It means the Constitution jealously protects multi-party democratic dispensation. So the Constitution doesn't want a situation where you go through an election and one party wins so many seats and decides to make a law that necessarily abolish other parties or force them and to create a one-party situation. Samson, the same Constitution is so clear that it doesn't want political parties to just think that their constitution are only for them and not public documents. So if you go to Article 55(7), the very first requirement for an organization to register with the Electoral Commission is its constitution. If you read 55(7), it says, for purposes of registering a prospective political party shall furnish the Electoral Commission with a copy of its constitution. That's the first thing that is mentioned.
Right.
So a party's constitution is not their private bona fide that they think they can handle to do with it any way and anyhow. The Constitution of the Republic makes provision for you to become a political party. You must submit, the first document asks of you is your constitution. So what you put in there becomes applicable in courts and in any situation where somebody has been given the mandate to interpret. And on a daily basis, nobody should fool himself that only Supreme Court interprets our laws. Every day when you have a mandate, the executive is interpreting laws by its programs that they do. Parliament is interpreting laws by its program that they do. It is only when there is an issue of question at a lower court, then of interpretation, understanding, it is referred to the Supreme Court.
That's not the only point.
Well,
when also, as an individual, I think that the meaning or the interpretation somebody has taken is not good, and that there is an ambiguity.
Exactly.
I can go to the court to determine whether there's ambiguity or it's clear.
You are right. So what I'm saying is that an institution that is implementing its understanding cannot say, I am referring to Supreme Court to interpret before I will implement.
Excellent.
And nobody is to pre-jump an institution and read into its mind like you are going to do this, therefore I'm going to court to seek interpretation. Afenyo Maki, the minority leader now, went to Supreme Court even before the matter was raised on the floor of the House. He went to Supreme Court. Yes. He went to court. Even before the statement was made under Order 93.
He went to court on the 15th.
Yes.
The statement was made on the 7th.
The statement was made on the 15th afternoon. He went to court in the morning.
Okay.
And that was when he saw
the statement was made on the 17th.
On the 15th Tuesday.
Correct.
15th Tuesday. That was when the then minority leader, now majority leader, made the statement.
So on the day the speaker was going to deliver his decision, 2 days after that day,
exactly,
he brought the process.
Then he brought the process. So he went to court even before a statement was made on the floor of the House. And like you said, it is only when an action is being taken and clear processes have been established to take a particular action, that one could decide that based on these steps that is being taken, I am going to Supreme Court to seek interpretation. In the case,
can I clarify?
No, wait.
Let him go on. You can.
I wanted to clarify a lot of things. Something asked me to wait. At the point I was even sleeping. I decided to sleep. So this was what happened. But you see, Parliament feels like in its workings, nobody, no institution should stop Parliament from the performance of what? Its functions.
In fact, this is the jurisprudence that people can use our own laws to show that until Parliament has done an act, you cannot question it. When they are done with it, then you can go and question it.
For example, not too long ago, this narcotics law, Parliament went through the processes
and passed
it. Somebody thought that one of the processes did not meet the constitutional threshold. So he went to court, went to Supreme Court, and the Supreme Court ruled on that aspect.
They struck it down.
They struck it down. And that they have a right to do. We have acted, we have finished. And then someone questions it. That is allowed. On this occasion, well, like I said, Afenyo King went to Supreme Court earlier than I thought he should. The action was taken even before the Supreme Court sat on his matter. At the time the Supreme Court was sitting on his matter, Parliament have already taken a decision. And what he sought to injunct Parliament from performing, Parliament has already performed it. And so, what is the result of that injunction?
It's not an injunction. It's a stay of execution.
Of course, stay of execution.
Stay of execution says you have done something. You are going to implement it. Hold on, don't implement it.
And I'm saying that we have already implemented it.
No, Barata, you have not implemented it.
We have implemented it. On the 15th, when the decision was taken, you have implemented it.
How?
Because the decision has been taken. Look, when Parliament decides on something, a matter such as this, if we were within maybe more than 3 months, and there was supposed to be further actions of the clerk writing to electoral commission, then we could stay those processes. But we are now within the 3 months period where there will be no need for a by-election. So you don't move to the other stages that the court is seeking to stay. In the understanding of Mr. Speaker, when we met again on Tuesday the 22nd, Parliament's decision, and not Speaker's decision, is Parliament's decision. When the Speaker makes, because the process started with a statement, Honorable Haruna wanted to come through a petition, and Honorable Atufosin came through a statement. And that statement was commented upon by many persons. And those who were specifically mentioned had a right to also comment on the statement. They chose to stay off from commenting. At least I knew the independent member of Parliament per parliamentary records was present. He did not comment because he knows that the statement that was made was right. And he, at least, has suffered it even before. So he did not comment. He did not rise for the Speaker to say that I'm not recognizing you. He did not. So all those who are talking about fair hearing, they were not heard and so on, nobody stopped them from commenting. None of them went on his or her feet for the Speaker to say, no, I will not allow you to comment. So now the Speaker rules, and as far as we are concerned, that ruling stays until Parliament itself decide through a process. Because Parliament takes act with decisions. And that is why the Speaker said, we have the numbers to do business, because that comes under Article 102, which is 1/3 of the numbers of members of Parliament. To be able to do that one, you need about 92, 93 thereabout. My mathematics, we don't have half human beings, so let's take it. let's take it maybe if it's a member that is presiding is a deputy speaker, then maybe 92. But if the one presiding is Mr. Speaker himself, then I think 93 is what I think. So between 92 and 93.
Speaker is not counted.
So he's not counted, but the deputy speakers are counted.
Right.
They are counted because they are members of what parliament. If
this
they are
92,
presiding,
that this parliament and your other parliaments, hardly you struggle to get that 92.
Well,
can you imagine this kind of parliament? And the day this decision was made, how many NPP MPs were in the House? There were about 7 or so.
The 17th.
Yes.
The Thursday when the speaker
That's right.
Yeah, there were not many of them. There were not many of them. The truth is that they are struggling to have their members attend to business of the House. That's the fact.
They are campaigning.
Their General Secretary himself have actually written a release to them that they should be in their constituencies and what have you. So that has been their focus.
Okay, so now let's come to where we are.
So where we are is that
they are written to compel the Speaker to recall the House.
And we know that the decision of Parliament on the 17th stays until Parliament itself, through processes.
So you mean even when Speaker recalls the House, the NDC will be majority?
The NDC will be majority.
Because the 4 people who have been declared are still off.
Are off, as far as Parliament is concerned.
That will be disobedience of the court order.
We are not disobeying the court's order. What the court is asking us to do, we already have done it. What the court is asking us to do has already happened, and so we cannot stay it. We can only go through a decision process.
The Constitution says that if the Supreme Court make orders and you do not comply by those orders, you are committing high crime. High crime can attract up to 10 years in prison. And after the service of the 10 years in prison, you are also prohibited from holding public office for another 10 years. If it is the president or the vice president who are caught in disobeying Supreme Court orders, that is grounds for impeachment. Do you understand how serious this is?
Parliament has already taken a decision.
Kofi.
Supreme Court spoke when? Supreme Court gave its so-called orders, not declaration.
So-called orders.
No, the orders, not declaration. Allow me to.
Kofi.
Not declaration.
You're my brother.
They gave the orders when? On the 18th.
On the 18th.
Parliament took a decision on the 17th. As far as Parliament is concerned,
and the court says stay.
The decision has been gavelled. The decision of Parliament has been gavelled, and so it is only Parliament, so properly constituted under Article 104, that can walk back its processes, and that is the understanding of Parliament. That is
the horses had bolted before the Supreme Court.
Before the Supreme Court.
So now listen, the principle of stay in law actually works in that way. You have done something, but you are now going to implement it. Then the court will say, don't implement until further notice. Well, this is what it is.
And I'm saying
so today, if Parliament is called, is recalled, and those 4 MPs decide to come to the House, and the marshals prevent them, or they come into the House and they are being asked to leave, or they try to rise and they are being stopped, or they try to speak and they are being disallowed, that will be disobedience of the orders of the court.
Well, that is your interpretation, as we all do.
That is a law.
And I'm saying that allow us, there are other lawyers who have also spoken. There are MPs who are also speaking. And I'm saying that our understanding and what we are using is that we have already decided.
So the recall will not happen?
Well, as for the recall, I'm now coming to the recall. The recall, when it happens, because constitutionally, the hands of the Speaker is in a way tied. Because it says when the 15% petitions, he shall, within 7 days after receipt of the petition, determine a date that should not be more than. The
petition was on 22nd, so next week.
Well, it was dated 22nd, but I don't know when
it was
served on the Speaker. Right. I doubt if it was served on the same 22nd, though dated 22nd.
All right.
So he may recall, but the question now is, is the minority NPP ready to abide by Parliament's decision on the 17th? If they are ready, then I believe that the House may be properly constituted to take a decision. But if they are not ready and they will stay in their offices, we may not have the numbers to do any business. And if they go and occupy the majority side, we, the NDC, will decide to stay out, and they would also not have the numbers to do any business. These are very clear. Again, there are already some legal actions that have been taken that stays the hands, and that person is coming under Article 99. And many lawyers who have spoken have said the right forum was not the Supreme Court, and that it should have been the High Court.
That's right.
If a question arises as to a vacancy, the right forum is the High Court.
The Constitution, Article 99, is very clear on that.
And that the forum should have been the High Court. And when the High Court feels there is any issue of interpretation, then maybe they can refer that to the Supreme Court.
It's a sound argument, but it's only one part. If a person believes that the terms of the Constitution in the manner they have been implemented is not right, they still can go to the Supreme Court to seek an interpretation.
Well, but Samson, where a provision is clear, there's a clear provision that it matters to do with vacancy. When a question arises, this is the forum.
Okay.
Where there is clarity, I don't think that we should be leaving it for people to decide that, oh, even though the Constitution, 1992 Constitution, not court practice or anything.
You're right.
Makes provision, clear provision. We should not be leaving it for people to decide that, oh no, I want to go to this forum because I feel they are the ones that are mandated to interpret. So somebody has gone to the right forum, seeking to support the decision of the Speaker and staying his hands from allowing them in. And
what do you think? That after the Supreme Court has said we have issued a stay, and I appreciate your argument, which says we have already done the thing, there's nothing to implement, so you can't stay us. I appreciate that argument. And some people have asked me the question, when Domolevo situation happened and the court gave its judgment, by the time the court gave its judgment, things had already finished. Could there have been a stay of the whatever it is? So the issue now, Kofi, is if Parliament is recalled, you, from what you are saying, even if the NDC don't go to Parliament, the NPP will still not have half.
They won't. Not in this state of the NPP that we have.
So they cannot be decision taking.
Look, let me tell you, no amount of whipping will get NPP, assuming even that Parliament decides that, oh, we want to allow the status quo as it was before 17th to stay. No amount of whipping will get NPP their 137.
This is NPP that has
I
flown people from abroad.
I am telling you that
on private jets just to come and attend Parliament.
Telling you that
this is NPP that has wheeled people in ambulances to the Parliament.
Samson, take it from me. Have you seen the number of NPP persons who are commenting on this matter? MPs. Have you observed? Have you observed the number of NPP persons?
They cannot be bothered.
They cannot be bothered. Did you see the number of them who were following their leader? Did you see?
Yeah.
Look, if Parliament today even decides that we are giving you the status quo as it was before 17th, the NPP will not be able to get 100 of
their cases. The new cases you are referring to, do you sincerely believe that a high court will take a decision different from what the Supreme Court has done? Well, that they are going to say, give us an injunction against the Speaker recalling. And then Supreme Court has already said, I've stayed your whatever, so let the process move on. Do you think
if the courts are minded to apply the law and the Constitution and not, say, be looking up that some bosses somewhere have spoken and so therefore I should just follow that, I think that the High Court can do so. I seriously think that. But I'm also worried. When there is so much clarity in the NPP's constitution, about forfeiture of membership. Then you get them come to sit and make all kinds of arguments that do not find space or comfort in their own constitution.
Their constitution does not actually require you to have filed.
To have filed,
it says once you declare, you have lost your membership.
It says, so we were even waiting for a document of a notice of polls, which is gazetted document to rely on. We did not base it on just mere declarations. We waited for a document, a notice of polls to act. Your constitution itself, that has been accepted, says once you declare, once you campaign for any other person against the legally elected party's candidate, you forfeit your membership. And now you come back without any provision that says that you'll have to go through their national council or council of elders and whatever. If there was any provision,
Gary hasn't said that. Some other people.
Yes, some other people. Yes, I'm not saying that Gary have said it, but you know, these matters we are speaking to what many have heard also.
That's right.
So that is why I'm bringing that.
Okay.
Not suggesting that Gary have said so on this platform. So clearly, I think that the NPP should just obey their own constitution as submitted to the Electoral Commission under Article 55(7). And as enshrined in their own, those persons have lost their membership. And for the independent, they say once you join a political party, in the case of the independent, it's so clear that if you are elected an independent and you join a political party,
okay,
so he has joined a political party, and MPs don't only work in parliament, in chamber. The MPs equally have other responsibilities in the constituencies and elsewhere.
Do you understand that this declaration affects these MPs, their gratuities, like they will be entitled to ex gratia, all of that is lost?
Of course,
it's been terminated. And then
no, I think it's a certain amount.
The thing that the presidents they normally do late, the constitution says they should do at the beginning of their office, but they don't. Their own emoluments. They wait until they're about to go out and then they bring it to Parliament. You approve their salaries and their gratuities. Can you imagine that you, the minority, become majority. And you are now going to approve Akufo-Addo's gratuities?
Well, that is the practice. That is the practice that have happened. And usually it is when we return after elections that we deal with those Article 71 and related matters. So I clearly know that there's work to be done. We are ready, we are prepared. This is a side, something that have cooperated to run government business. Okay. Even when we were in court, that's my last point. Even when, as a party, we were in court against the 2020 elections, we sought to approve the budget that was read by Honorable Chairman Sabonsu and not the finance minister, because at that time they didn't have one. We approved all the nominees. If we were there to frustrate government business, that was when we would have frustrated that government business. Okay. So we are not doing this to frustrate any business. We are doing it because the law says so. And we must all be law-abiding. They should advise their people appropriately and rightly for them to return to the seats where they are supposed to sit. They are in the minority now until Parliament says otherwise.
Okay, thank you very much.